Hello and welcome to the Entrant. Today's topic for discussion is agreements, proposals, and contracts under the Indian Contract Act 1872. This topic holds of great importance in our everyday lives as it's essential for one to know and understand the difference between offers, agreements, and legal contracts. An agreement, according to Section 2E of the Act, is defined as every promise and every set of promises forming the consideration for each other. A promise, when accepted, becomes a proposal. Every agreement is a result of a proposal from one side and its acceptance from another. An agreement can be oral or written. Written agreements have a greater evidentiary value in the court of law as they are easier to prove and understand. Oral agreements, on the other hand, are expressed through hand gestures and therefore lack the evidentiary value as they are obtained via second-hand knowledge. There are various types of agreements such as valid agreements, voidable agreements, and illegal agreements. Valid agreements are those agreements that are enforceable by law and satisfy the condition of a valid contract under the Act. Voidable agreements are those agreements enforceable by law at the discretion of one of the parties to such an agreement. Agreements induced by coercion, undue influence, fraud, and misrepresentation are voidable. Void agreements are agreements that have no legal effect at all and therefore no action can be taken under such an agreement in a court of law. Such agreements are also known as void ab initio, that means void from the very beginning. Illegal agreements are those agreements which are void because they are against the law. For example, wagering agreements or agreements to buy smuggled opium. The term illegal is narrower in meaning than the term void. All illegal contracts are void, but not all void contracts are illegal. For example, an agreement to restraint in trade is void but not illegal. A proposal is when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of the other person to such act or abstinence. He is said to make a proposal. This is laid down in Section 2A of the Indian Contract Act. The term proposal of the Indian Contract Act is synonymous with the term offer of the English law. An offer, in order to give rise to a contract, must be intended to create and be capable of creating legal relations and a legal duty. Social or moral relations will not give rise to legal obligations. A proposal should be with the view to obtain the assent of another person and not just a fact or a statement. For instance, I am willing to die for my country is a statement, as against, I will sell you this pen for ₹50, which is a proposal. A proposal, in order to give rise to a contract, must be intended to create and be capable of creating legal obligations. Here are a few illustrations to help understand the concept of a proposal better. A mere statement made during a conversation will not amount to a proposal. In the leading case of Weeks versus Tybalt, A has said to B that he intends to give ₹1,000 to anyone that marries his daughter with his consent. In the circumstances, there would be no contract as A's statement was not an offer. There must be a promise to do or not to do something as a legal duty. For example, in an English case of Balfour versus Balfour, Mr. B was posted in Ceylon, promised his wife to pay a monthly allowance as long as she would not go to Ceylon for health reasons. When Mr. B failed to honor his promise, she filed a suit against him, and the court held that she could not enforce the obligation. There was no intention to give rise to a legal obligation, it was merely a domestic arrangement. All agreements are contracts if they are made with the free consent of parties competent to contract for a lawful consideration and with a lawful object and are not declared void. When an agreement enables a man to compel another to do something or to not to do something and creates a legal obligation, it is called a contract. A legally enforceable contract gives rise to legal remedies when there is a breach or non-performance of the contract. An agreement is a wider concept and it includes social, religious, and legal agreements. However, all agreements are not contracts. An example of all agreements are not contracts would be A invites B for a party at his house. B agrees, but unfortunately A falls sick and cancels the party. In this case, B cannot file a suit against A as it's only a social agreement. It was not meant to create legal obligations and therefore is not a contract. Taking the example of Mr. B, who is a cupcake vendor and wishes to sell his cupcakes to Mr. A, we will understand the essentials of a valid contract. An offer. Mr. A will pay Mr. B ₹800 for 100 cupcakes. an acceptance of the offer. Mr. B accepts the offer of 800 rupees for 100 cupcakes. A promise to perform. Mr. B says that he will perform. A valuable legal consideration, that is rupees 800. A time or an event of when the performance must be made. 100 cupcakes must be delivered exactly 10 days from now. Terms and conditions for the performance. The cupcakes must be chocolate and have strawberry frosting. And the performance of the contract. The 100 cupcakes are delivered by Mr. B and Mr. A pays rupees 800 to Mr. B during the deliverance. An agreement is an offer plus promise plus consideration, and a contract is an agreement plus legal enforceability. All contracts are agreements and all agreements are offers, but not vice versa, as explained in the diagram. I hope this video was helpful in providing a simple and clear understanding the concepts of agreements, proposal, and contracts. For any further queries, please drop your questions in the comment box below, and don't forget to like, share, and subscribe. Thank you.